Good afternoon, everybody. I hope this finds everybody healthy and safe and doing well. Mental health and wellness are always of great concern at Berkeley Law. That's especially so now in the midst of the pandemic, where we're all being kept separate. Last week was a focus on mental health and wellness, terrific set of programs that have been put together. I especially want to thank Emily Bruce and those in the Student Service Office who are responsible for this. Kyle Valenti, Kyle Kate Dudley, Amanda Tran, Kristen Haas, and of course our Assistant Dean for Students, or Dean of Students, Anik Hershen. We're also in the midst of doing a series of programs on aspects of race in the law, and it seemed important coming together here to do a program that looks at issues of race, law, and mental health. And I'm so grateful to the four speakers we have today who will address aspects of this topic. I'm going to do short introductions of them in the order in which they'll speak. As always, I apologize to the speakers that my brief introductions don't begin to do justice to their terrific qualifications, but I don't want to take too much time away from their presentations. Our first speaker will be Professor Michele Goodwin. She's a Chancellor's Professor of Law at the University of California, Irvine Law School. She's the Director of the Center on Biotechnology and Global Health Policy Law. She's the author of many publications, including several articles with this Chemerinsky guy from Berkeley. Our second speaker is going to be Mallika Kaur. She's a lawyer and writer who focuses on gender and minority issues in the United States and in South Asia. She holds a Master in Public Policy from Harvard and a JD from our own UC Berkeley Law School. And she teaches a class here. The class is one that she's designed titled Negotiating Trauma, Emotions, and Practice of Law. Her recent book, Faith, Gender, and Activism in the Punjab Conflict, The Wheatfields Still Whisper, was published by Palgrave Macmillan in 2019, and it focuses on human rights defenders and engages with questions of collective intergenerational trauma. Our third speaker will be Professor Vicky Plaut. She's the Claire Sanders Clements Dean's Professor of Law. She's a cultural and social psychologist. She's taught at a number of universities, including joining the UC Berkeley Law School in 2010. And our final speaker will be George Woods. Dr. Woods is a practicing physician specializing in neuropsychiatry. He consults with legal teams regularly dealing with complex criminal and civil litigation. Dr. Woods was appointed to the San Francisco District Attorney's Post-Conviction Unit Innocence Committee in August 2020. He's the president-elect of the International Academy of Law and Mental Health. For the last 8 years, he's taught a course on mental health and the law here at Berkeley Law. So without further ado, I'll turn to Professor Goodwin to begin the remarks.
Well, it's a pleasure to be with you, Irwin, and this esteemed panel, and thank you all for tuning in. My remarks will be about the second guessing of ourselves, and I think the intersection of thinking about race and mental health says so much and is a potent position from which to start this discussion. And I want to root it in thinking about the concerns of women and the second guessing of ourselves and the trauma of women of color. You may think of Sandra Bland, whose death still remains a mystery after a traffic stop, or even Breonna Taylor and the protests now taking place to say her name, to remember her with dignity and respect, and to also do an inquisition about law and how we get to this space and what does justice mean in the space of a Black woman being shot multiple times in the middle of the night. But this trauma that you can connect to those stories of Sandra Bland and Breonna Taylor actually dates back much further and is important for us to keep in mind. This is a trauma that's rooted in the perversity and complicity and complexity of law in our American story. You might think about it within the context of the antebellum rootedness in our country, or even through the speech of Sojourner Truth, which is often trotted out as the "ain't I a woman" speech used to talk about chivalry. But there's something deep in the trauma of the soil in which we live, because as Sojourner Truth said in that very same speech, and perhaps this will resonate as we think about Latinx mothers in recent years, she said, "And I bore 13 children, and nearly each one snatched from my arms, and nobody heard my cry but God. Ain't I a woman?" These kind of systemic legal interactions in the lives of women of color, rendering them not only without rights, but making their souls suffer at the same time. We can think about that legacy on a reproductive rights and justice arc when you think about the following, which is that America's enterprise of using the Black body, the Latinx body, the indigenous body, to whichever means it desired to. Black women's bodies were used and capitalistic chattel in the United States for an enduring chapter of our legal history. A very recent study by 23andMe bears out the horrendous platform of sexual assault and rape that was mixed into the American soil and foundational to the enterprise of American slavery. And when I begin my talk by saying the second guessing of ourselves is because these systems themselves challenge people to understand their own human dignity. That is, in fact, what is behind the cry of Sojourner Truth saying, "Ain't I a woman?" And of course, this is what happens in a society that says that you are no more than property, that your children do not belong to you, but that they belong to someone else. It is said that one of the most frightening and horrific days on the plantation was the day in which the auctioning was to take place, because this was the day in which mothers and aunts and grandmothers and grandfathers and fathers knew that their children could be sold away, knew that they could be sold away from their children, and knew that this would interrupt the bonds that they knew that they had, even though they were rendered to a status of no more than property. But this exercise of using the body, particularly women's bodies, in the force of law for the purposes of other people wielding their own power, continued long beyond slavery. And we see the vestiges of this rearing up very recently with regard to forced sterilizations, something that Dean Chemerinsky and I have written about within the case of Buck v. Bell. We know that this legacy endures. In fact, it is said that at one period of time, a third of the women in Puerto Rico were sterilized. It became so common that it was just known as la operación, it just happens. In Mississippi, it was known as the Mississippi appendectomy, and really beyond that, to reference the fact that there were girls as young as 10, 11, 12 years old who were subjected to these procedures, often without their knowledge of what was actually happening to their bodies, only to find out later. And indigenous women were neither spared this either in the United States. Today, we see challenges of this in Georgia detention centers, where women who are held, who are seeking asylum in the United States, have recently made claims that they were sterilized against their will, and that is currently being investigated. But before I wrap up my remarks, I want to think about other ways too in which we see how the body becomes this source of a kind of source where terrorism is inflicted upon it. And that is not a kind of exaggerated kind of terminology if you really think about the kind of history that I'm talking about here. And so I want to relay a story that is in my new book, Policing the Womb, Invisible Women and the Criminalization of Motherhood. And it's actually a story that is not about abortion. It's actually not about sterilization, which I've just talked about, but it gets to this question that we're talking about in terms of race and mental health. And it also furthers what I want to talk about in terms of sex. And it's the case of Ms. Barbara Dawson. Miss Dawson was a person who called the ambulance to take her to a hospital. She wanted to go to the hospital because she could not breathe. Now, if you were to see an image of Miss Dawson, maybe you too would think of her as I do. She looks like a Black grandmother on her way to church, her red hat slightly tilted and her dress kind of smiling into the camera with a kind of softness but sternness at the same time because it's time for church. That's how I saw Miss Dawson, but she was seen in a very different way by law enforcement and by people at the hospital where she sought treatment. So the ambulance comes and it takes Miss Dawson to the hospital where she complains that she cannot breathe. But at some point, the hospital is tired of hearing this from her. And in fact, they call the police for her to leave. Now, there's so much about this story that makes no sense. What makes sense is that she calls the ambulance because she can't breathe and that she's at the hospital. But after that, nothing makes sense. But this is where Miss Dawson is put in the position of actually having to question herself. And here's the rest of the story. The police arrive at the hospital. Officer Tadlock's camera captures the audio, which is how he says in a very calm voice, "You have to leave the hospital and you're being arrested." And she says, "You can't do this to me because I can't breathe." And he says, "You have to just stop playing around because you're now going to jail." And she says, "No, God, no, I can't breathe. You can't do this to me." And Officer Tadlock says, "Well, yes, I can do this to you." And what you learn from the police transcript is that the hospital becomes complicit. Someone at the hospital points to a port on the wall because this is where her oxygen can be removed from her. And she cries, "No, God, no, you can't do this to me." And Officer Tadlock, along with the assistance of someone at the hospital, handcuff her, put her hands behind her back, and they say, "You are going to jail." And she says, "You can't take me to jail." And Officer Tadlock says, "Well, yes, I can." When they get outside of the hospital, right at the less than 20 feet away at the squad car, she collapses. Officer Tadlock can be heard saying to her, "Playing around like this isn't going to save you from going to jail." And you hear her niece saying, "But she can't breathe. She's not playing." She dies right there with a blood clot in her lungs. I share this story because health is also mental health. Mental health is also health. And when we think about law, law can provide the means that treat people in ways of dignity and respect and integrity. You can think about the Affordable Care Act and the mandates in there to try to afford people who are poor health care, but law can also be a tool in the criminal justice system that renders people's rights meaningless, where the rights become more illusory than real, and where you can see in this particular case, a Black woman who says that she can't breathe is actually questioned about whether she can actually breathe, and this system itself collapses on itself in the death of people who are like Breonna Taylor, Sandra Bland, and in this case, Miss Barbara Dawson. Perhaps during Q&A, we can talk more about what all of this means, but I think it says something about an ongoing trauma and mental health that is more than just someone being diagnosed as having some mental health condition or problem, but a problem within the system itself that causes lingering trauma and harm to people of color. And I'll end there.
Thank you. Mallika?
Thank you so much. It's a privilege to be part of this esteemed panel. It's also an immense privilege to be speaking today on Indigenous Peoples Day. So first, we recognize that Berkeley sits on the territory of the Huchun, the ancestral and unceded land of the Chochenyo-speaking Ohlone people, the successors of the historic and sovereign Verona Band of Alameda County. This land is and continues to be of great importance to the Mu-Vekmu Ohlone tribe and other familial descendants of the Verona Band. I'd like to thank our campus's Native American Student Development Office for this living land acknowledgement. Berkeley was the first city in 1992 to reclaim today as Indigenous Peoples Day to coincide with the anniversary of Christopher Columbus's arrival in the Americas. Communal and racial traumas, historic and current, often now replayed regularly with video evidence, are of course intertwined with mental health. And then you stir in the law to that intersection, the writing of laws to propagate and condone violence, from early US laws of settler colonists to 2020's legal immunities for torture abroad or torture on our streets here at home. The practice of law prioritizing a normative perspective and litigation strategies that take advantage of mental health and trauma, often in the name of zealous advocacy. Or even the teaching of law and the culture around the law and the mythos around US law, gladiator-like, which ignores trauma and pushes emotions often as secondary to be referred out to other helping professions. For certain, what keeps us going, attracts us to the law, retains us even in the profession, is a belief in the rule of law. For those of us who've known and fled countries without rule of law, for those of us whose peoples have pushed for changes in the law that then provided equity for everyone, and for those who channel all their outrage and their inner turmoil this way. The evolution of law and the law at its best and boldest on the page and in praxis does educate, does motivate, does even emancipate. And yet, because of law's complicated relationship to race, racialization, minoritization, as well as the legal practices, overwhelming, hypernormative, heteronormative, conformist experience for too many, in this profession, we're constantly negotiating emotions and even traumas. But we seldom speak about these emotional negotiations holistically. So thanks so much for organizing this panel to Dean Chemerinsky. And this panel on mental health and wellness is not just for the attorney who's prosecuting child sexual assault or domestic violence attorney or the capital defense attorney, but also in today's economy and today's reality, these are questions for the small business attorney, the bankruptcy attorney, of course, the immigration attorney, the estate planning attorney, we've just seen the environmental attorneys who are trying to apply analytical skills in the face of existential crises. I am not a scientist, I'm not a psychologist, I'm not a therapist, but I do work with trauma survivors and I teach and train lawyers and law students on trauma. So I'll divide my remaining time between speaking about the profession, mental health and race, and then lawyers in training law students, race and mental health. So as a general matter, I think it's quite safe to say that our profession and our legal culture as a whole does not reward vulnerability, uncertainty, or feelings. The public defender of Marin County, Jose Varela, proud Berkeley law alum, I think sums it in a way that always sticks for me at least, about how he's noticed that lawyers in the past would always dance with the Ds, and he has 5 Ds: depression, drugs, drinking, divorce, and death. And he says they would dance with the Ds rather than acknowledge trauma head on. The good news here is that my friend Jose does so much in his office to reduce harm, to reduce burnout, to reduce attrition for attorneys providing indigent defense. And indeed, today, in many legal practice areas, especially if you're in a geography like ours in the Bay Area, it might seem that trauma trainings appear on the regular in legal conferences and in continuing legal education. But still, even where this is so, trauma-informed lawyering and self-care are separated out, which I think is particularly disadvantageous to lawyers of color. So first, about trauma-informed lawyering. We have slowly somehow sold ourselves as a profession to the idea that learning, thinking, knowing about clients' traumas makes us better attorneys. And I think that's true. So for example, with interviewing methods that are less of an interrogation, more of a conversation, we get more information. Or with knowledge about physiological reactions a client has to trauma, we better understand how to work with them and build trust. Or by sharing more details, building in more flexibility, we reduce anxiety and help a witness present better. So there is some recognition that trauma is understanding trauma and being trauma informed is to the benefit of lawyering. But when it comes to lawyers' own traumas, there is still much resistance, even shame. The type of statistics we know about lawyers and unhappiness, lawyers and substance abuse, lawyers and attrition, lawyers and even suicide, those larger problems cannot be solved by just a longer lunch, an extra walk, an extra mental health day, or massage chairs in law firms, which a student informed me last year was a recruiting pitch that he got. Moreover, for attorneys of color, often these two things, trauma-centeredness and self-care, are deeply related, especially for attorneys who themselves and students who themselves come from histories of trauma. So take the definition of trauma stewardship by Laura Vandernoot-Lipsky, which is Trauma Stewardship as a book has been helpful for a number of my friends in different helping professions. But she says this framework of trauma stewardship, gently guiding and engaging oppression and trauma, whether through our careers or personal life, is about caring for, tending to, and responsibly guiding others who are struggling. At the same time, she says, we do not internalize others' struggles as our own or assume them as our own. Point taken about not co-opting somebody else's trauma. That's an important lesson. But what about when you share in the very struggles that you're being advised to not make your own? As someone myself from the Sikh community that survived pogroms and mass violence in the 80s and 90s without any reparations till date or any closure or justice, I relate to human rights attorneys and social justice lawyers who will say that their inherited identities are not something they're trying to run away from or fix. So then a holistic trauma-centered approach, I think, is one that accepts different individual baselines, different ideas of self-care, different relationships with trauma. One size fits one. Now that we're all at home, we're seeing that home looks very different for each of us. Home means something different for each of us. And we have even seen that the same kind of global trauma affects us all individually very differently. Understanding that trauma and emotions are not a footnote, not to be only referred out, rather as at the core and center of someone's experience, sometimes even their legal case or representation, is what trauma-centeredness is about. It's an approach that encourages us to figure out our own traumas or other strong emotional reactions and how they intersect with tasks at hand, and then what self-care we truly need. So instead of allowing self-care to become a buzzword that conjures up bubble baths or perhaps wine, depending on the legal shows, The Good Wife, for example, that a lot of folks watch. But on a serious note, regarding self-care, for it to be something that truly loves you back for the long haul and not a temporary fix or solution. The ABA's landmark study in 2016 of 10,000 attorneys showed that 36% screened for problem drinking, higher than other professions at that time. The number for doctors, physicians was about 15%. So if trauma is centered, I also think we don't shy away from recognizing these truths. And then we also don't begrudge making changes or being flexible. COVID and everything that has followed has shown us that there's much more flexibility. We could have perhaps always awarded folks, especially those struggling with normative structures, while managing individual challenges. It's also illustrated that we only began offering and making flexibility the norm when neurotypical folks, those without mental developmental learning differences or disabilities, it was only when neurotypical folks, the majority, really needed the flexibility that somehow it became possible in some ways almost overnight. Trauma-centeredness may also be helpful to make sense of the range of feelings one feels when you say you're the only person other than your client who's a person of color in a courtroom or a boardroom, or what it means for the woman of color attorney to repeatedly being assumed as a court reporter or translator. And also, as noted by this year's ABA study, sadly titled "Majority of Minority Female Lawyers Consider Leaving the Law." Leaving, in fact, may even be less stigmatized than staying and speaking feelings, hurt, scared, confused, sad. Especially when you're from the global majority, minoritized in US culture, these can be very difficult conversations of difference and of feelings to raise. And in thinking today, I also remembered a client, speaking about global majority and trauma. I thought about a client who, besides coming from a history of trauma, also had a significant and undiagnosed mental illness. During our first meeting, she signaled that she might be hearing different voices other than my voice that was listing legal options. And I asked her if she could take a minute or more to talk to the voices and see if they would afford her some quiet. And also asked her if the voices were more likely to silence inside our office or outside in the garden. She took the time she needed. We were able to have a pretty exhaustive and long meeting. And pairing up with her mental health professional later was, of course, indispensable. And I'm not sharing this to say that I cannot recount other stories where there are numerous cases where similar attempts by me or other attorneys didn't yield such results. But I share this to make the point that at times just accepting somebody's reality for what it is rather than trying to fix it or thinking it's outside our job description or that it's special or that it's stigmatized and it's beyond us. Sometimes all people want is accepting this is their reality and you see it for what it is. So I'll turn for the remaining minutes just to how it's not just clients and attorneys in practice who feel crushed by the expectations of fitting in the normative or what is supposed to be the normal mode of the legal system. I'll turn to law students. Mental health is often more generally referred to as stress, maybe burnout, even hazing of the 1L year. And these can be appropriate descriptions for some students, but very gentle euphemisms that don't even begin to encapsulate challenges for many others. And we are talking about a huge umbrella here, right? Mental health could be a pre-existing condition with a diagnosis, itself a privilege. It could be a neurodiversity not thought of as a disability by the person. It could be an individual or a collective trauma not coded by that person as mental health. So example, an unexpected reaction to reading Clinton v. Jones in torts class, or walking into a classroom minutes after watching yet another gruesome killing of someone who was driving, walking, talking, breathing, sleeping while Black. Or the story you heard today of someone who went into the hospital because she couldn't breathe and was pushed out of the hospital to die right outside. It could be a trauma response to reading Korematsu in con law without an acknowledgement of the heavy weight of that case on an entire people and community. So I wanted to make sure today that we do include the voices of students in our Berkeley law community who identify as having mental health concerns. I spoke to a few students last week, a few former students. I'd particularly like to thank our 3L Anuramdeen for her integrity and insights. One student said that recognizing her mental health as a disability is not something that she'd ever been pushed to do before law school. So disability accommodations didn't necessarily feel like making law school a more inclusive place. Other students commented on the hypervigilance that they felt constantly in law school of being people who were more neurodiverse and who were also racial minorities and who felt like they were being judged and had to present a certain way, and that constant hypervigilance was very exhausting. First generation students also often report being confused by the inside speak of law school, which makes it seem like all others are very comfortable being people-facing, thinking on the fly, Socratic method tested, and true orators. So I'll close by just saying that if we can share our own personal vulnerabilities as well as our privileges with lawyers and law students with more honesty, we could create an environment where people do truly feel comfortable negotiating belonging and unbelonging and holding those conflicting feelings and that inner turmoil with more confidence and with lesser negative consequences, especially not feeling like we are not accepting of diversity as institutions and as a culture. Thank you.
Good afternoon, everyone. Thank you so much to Dean Chemerinsky and the Berkeley Law staff for organizing this panel, and very grateful to be here with my highly respected colleagues whose work, who have already drawn out so many important issues for us to think about. Threats to belonging are one of many important shapers of mental health for minoritized or historically marginalized racial groups. And that's what I'm going to talk about today as a social psychologist. So keeping to my 15 minutes, I'll talk about what belonging is and why it matters, some mistakes we make in thinking about it, and I'll provide a set of concepts for unpacking common threats to belonging. And very, very briefly, I don't think there'll be much time for this, I'll describe a framework for creating belonging. A couple notes. First, I'll focus mostly on race, but I'll also borrow from research available on other axes of inequality. And second, I'll focus mostly on concepts that are relevant to workplace and educational settings. A recent Washington Post article headline states, first there was diversity, then inclusion, now HR wants everyone to feel like they belong. And if B stands for belonging and D stands for diversity, in a sense, B is now the new D, at least in corporate America. And it's also making its way across institutions of higher education. Some would go as far as to say that diversity and inclusion aren't what matters, that belonging is. But I hope to show you that you need to address diversity, equity, inclusion in order to have belonging, and that this matters for well-being of historically excluded groups. Okay, so belonging, what it is and why it matters. What is belonging? So this is a word cloud that was generated when I asked my undergraduate class this very question. And what they came up with comports with common definitions that stress that belonging is a feeling with a focus on whether you feel part of something and feel like you can be your whole self. As an example, according to one professor who is a woman of color at an elite institution, quote, belonging gives name to the growing tightness between my shoulders as I approach campus each day, arranging my mental armor to defend my own sense of worth. Why does it matter? Belonging is a human need that can affect a host of psychological and physical health outcomes. For example, well-being, mental health, stress, distress. In terms of mortality, one study estimated a 50% increased likelihood of survival for participants with stronger social relationships. It can also affect a variety of outcomes at work and at school. To give you a sense for the magnitude of the impact, when aggregated, one study estimated that for a 10,000 person company, the annual savings of having high belonging would be 52 million. That's not to say that that generating savings is the reason to try to foster belonging, but it provides a sense for just how powerful it is. So belonging matters. In addition, we know that organizational and interpersonal inequities and harassment contribute to mental health outcomes, often through a sense of belonging. So low belonging can signal that something is wrong with processes of equity and inclusion in an institution. But we often make mistakes about belonging, and I think that some of these mistakes were put into high relief this summer as organizations grappled with racial unrest and the murder of George Floyd. We don't think about it, especially if we have privilege, representation, or power. So certain people, especially those in power in an organization, may often take belonging for granted because the organization was built for people, by people, and for people like them. So they might not think about it. Second, we might think of it simply as community, feeling good or being nice to people and be insensitive to the hierarchy of belonging challenges. Third, we might think of threats to belonging as overt acts of discrimination and not as a whole set of more subtle and cumulative experiences. And finally, we might make declarations, as many institutions did this past summer, without addressing underlying issues or the whole culture or the whole structure. So what are some conceptual tools for unpacking experiences of belonging? So here we'll start with something very basic. Okay, so if you have a look at this set of survey questions here, if you would answer yes to any of these questions, for example, number 6, I'm afraid people important to me may find out that I'm not as capable as they think I am, then you may experience imposter syndrome or the imposter phenomenon. These feelings are quite common. They're common in the workplace. They're common in educational settings. I'm sure they're common among first-year law students. One study estimates that over 70% of the US population has experienced imposter syndrome. Another example of a conceptual tool to begin to think about belonging is the following. So think about whether you've ever been sitting in a meeting or a class and felt like the presenter or the instructor said something that you didn't understand. And then when you looked around, you assumed that everybody else did understand. So that's called pluralistic ignorance. And it's when you believe that what you're thinking or feeling on the inside is different from others, even though your behavior on the outside is identical. So in the meeting example, what's everyone doing? They're looking at the presenter or looking like they're taking notes or looking at the screen or the camera if it's on Zoom in our new reality. You infer that they know what's going on while you don't. And chances are they're thinking the same thing. And the consequence is that you misperceive the social norm. And this misperception of the social norm can actually have grave implications, including feelings of alienation. So both imposter syndrome and pluralistic ignorance are common, but they can be compounded for marginalized or non-dominant group members due to some of the phenomena that we're going to discuss next. So let's try another one. Think about whether you've ever been in a room of people or on Zoom and counted how many other people with your identity or a certain intersecting set of identities are there. And psychologists have studied that too. It's the way that being the only one from an underrepresented group is highly salient to you. And being the only one or one of just a few can have a host of consequences, including feeling heightened visibility and feelings of scrutiny or even pressure to represent one's group. And it's been linked to reports of lowered job satisfaction and other psychological satisfaction measures. And what we know as well is that companies may be thinking way too simplistically about representation in their diversity efforts. So for example, in one study that my research group has run, where we show people pictures of different tech teams, and these are only 2 of the many sets of pictures we've shown them, although Black women who were participants in our study saw tech teams with Black men as more diverse than other teams, racial or gender representation alone did not foster belonging. And often when institutions such as companies are thinking about diversity, they're thinking about it in a very singular way and not thinking about the intersection of different identities. Another concept that we can apply to think about belonging in educational and work contexts is stereotype threat. So that's the threat which is elicited by the environment that one will be viewed through the lens of a negative stereotype or the fear of doing something that will confirm the stereotype. And it's been found to result in higher levels of stress and anxiety as measured by cortisol and cardiac functioning, lower working memory, worse performance on a variety of tasks, including tests, and expressed career interest that deviates from what one was interested in to begin with. And one study found that African American women who experienced stereotype threat in their place of work were less likely to seek professional development. Another construct is ambient belonging. So another hypothetical, think about whether you've ever walked into a space, whether it be a public space, a workplace, an educational setting, a classroom, and it just felt like you didn't belong. Like something about the space was communicating to you that you didn't belong there. So psychologists have studied the way that space has cues and signal belonging to certain groups. My colleague Sapna Cherian and I coined the term ambient belonging to describe this. So for example, when you walk into a courthouse, are there only pictures of white male judges hanging on the walls? And what does this communicate to you as a lawyer or as a client? And what does it communicate about access to justice? Or if you walk into a tech company, are there lots of Nerf balls? What are the implications of these cues? In one study, for example, we looked at this by asking students about their interest in computer science. And we did so in a room that was filled with stereotypical cues or filled with non-stereotypical cues, like a nature poster versus a Star Trek poster. And we found that women were much more interested in computer science in the non-stereotypical room because it heightened their sense of belonging. Sociologist Elijah Anderson has said that while white people usually avoid Black space, Black people are required to navigate the white space as a condition of their existence. So these spaces are often ones that were built by and for a certain group of people. And sense of belonging is highly relevant to reports of how students feel on college campuses, with racially marginalized groups reporting lower belonging and feeling like it's not their space or like they need an invitation to enter the space. One can look around most historically white spaces and find ample examples of historical depictions that tell one story to the exclusion of others. For example, on this display of Berkeley's history, one can imagine telling a very different story, including about the Ohlone land that it sits on. And briefly, cognitive depletion is another phenomenon. Psychologists have studied the mental exhaustion for Black, Indigenous, and people of color that can accompany interracial interactions. And this can occur for a variety of reasons, even with well-intentioned people. But these interracial interactions can result in negative and inconsistent signals that are exhausting to deal with. And finally, taxing experiences, dealing with repeated questionings of one's belonging. So as Professor Kaur mentioned, being mistaken for a court reporter or for a translator. Always having to educate people, for example, about racism, the burden of having to conform or assimilate to a dominant norm repeatedly, and finally, the cumulative impact of these. As Chester Pierce said, the psychologist Chester Pierce said in 1970, most offensive actions are subtle and stunning. The enormity of the complications they cause can be appreciated only when one considers that these subtle blows are delivered incessantly. Okay, so creating belonging. As I mentioned, we don't have too much time to go into this, and I've covered a lot of ground already in trying to give you some conceptual tools for unpacking experiences of belonging. I've also tried to argue that belonging is a product of diversity, equity, and inclusion and cannot happen without it. You can't just be nice to people and expect them to feel like they belong. So in order to produce settings that foster belonging, you have to attend to the other components. The main idea is that you therefore need a multi-pronged approach that focuses both on the culture and structural issues and on ensuring pathways for success for employees or for students. So if you're looking at an organizational design for belonging, these are some of the areas you would want to address. And if you're designing an educational institution, the details might be a bit different. I'm at my 15 minutes and I'll stop there. Thank you.
Good afternoon. I've got to stop for a moment and kind of pull myself out of the previous conversations. They were really just so fascinating. I'm sitting here taking notes, and now I've got to make sure that the notes that I'm going to use are the ones that I had for my presentation and not the notes and questions that I had for the three astounding presentations before me. I'd also like to thank Dean Chemerinsky for inviting me today. I've had some practice at this because Friday I taught my class on mental health and the law, and this particular section was on race. And so I've had a chance to think about it, and as both professors spoke before, to hear from my students about how they are looking and learning and teaching me about these issues. One of the terms that has come up repeatedly in this conversation has been intersectionality. And I've been so thinking about the question of intersectionality, really looking at it as it relates to race, mental health, and the law. And I'm going to just quickly read a definition of intersectionality. I know we all have an understanding of what it means, but I want to make sure that I can frame this conversation. Intersectionality is a theoretical framework for understanding how aspects of a person's social and political identities combine to create different modes of discrimination and privilege. Intersectionality identifies advantages and disadvantages that are felt by people due to a combination of factors. You know, even though we see discussions of intersectionality in mental health, in both psychology and psychiatry, I really believe that the discussions of intersectionality have not been very fruitful when we talked about race and law, and particularly race and law and mental health. And I think it really has to do with the qualities of the various disciplines. Mental health is a scientific discipline. It is science-like. And in many ways, it is broad and it is evolutionary and it is inquisitive. And in many times, it's unknowing. The law, on the other hand, often is looking for more specific answers and looking for a certain quality of answer that can provide a specific approach. And that's not what you see in mental health. And so what I often feel like when we're talking about race, mental health, and the law, is this kind of, particularly race and mental health and the law, it's this kind of immiscible relationship. It's kind of oil and water relationship with some collard greens thrown in. And it becomes very, very complex, and not only complex, but it becomes very difficult to really get to the essence of what we're trying to do without some negotiation. And so I wanted to talk about three quick areas that I think with this really illustrates this difficulty. The first one is a paper that was written in 2009 by Goodwin on race norming in neuropsychological testing. So when we think about race norming, and certainly when we think about neuropsychological testing, we're thinking, wait a minute. This is the brain. Everybody's brain is kind of the same. You know, we all have neurotransmitters. We all have synapses. You know, can it really be necessary to look at race norming when we are doing neuropsychological testing? Well, the answer is, of course, it is, because culture affects genetics. Culture affects biology. Culture, in fact, trumps biology. And when we don't think of culture as being as relevant and as scientific and as shaping as the biology or the genetics, we lose. And so often that's the situation that we're in, is that we don't take culture, we don't look at culture as being every bit as valuable, every bit as shaping, every bit as emphatic as the biological sciences or the genetic sciences or the physical sciences. And so what you see in this struggle to kind of determine how do you race norm in neuropsychological testing because, as we see in IQ testing, people of color, people often do much less successfully in neuropsychological testing than people in the majority culture. How can that be? It doesn't matter whether they have gone to Berkeley or at Stanford. It doesn't matter what their family history is like. Somehow those 10 or 15 points that Jensen always describes to being inferior, somehow those 10 or 15 points are always there. So how do we approach it? And much of my work is with capital cases, but civil cases as well. The ways in which we've approached it historically have been through three factors: acculturation, socioeconomic status, and quality of education, none of which are satisfying. Acculturation. Well, okay, if someone is of a similar culture, or if you are a person of color, but you have gone to a certain, avenues of education, of work, you must be acculturated. And I would suggest to you that that certainly doesn't fit. Maybe assimilated, but not acculturated. I am pretty well educated. I was lucky enough to live in Little Omaha, Nebraska, in a family that was together. If in any way you think that I am acculturated, you're making a grave mistake. Right? You're making a grave mistake. Assimilated, perhaps. Acculturated, it's not going to make me win in this neuropsychological battle. Similarly with socioeconomic status, right? We take the socioeconomic status, we try to apply that to somehow ameliorate those points so that we can be closer to what Bill Lawson, as the NIMH says, I wish that all my clients were white so that my research would be real. And yet it still doesn't work. That socioeconomic status, the fact that you make the same amount of money, or that you come historically from a family or that has a certain socioeconomic status, it doesn't work. It doesn't ameliorate. It doesn't allow that interdependence, that intersectionality that we're looking for to try to make these tests work. Same with quality of education. Quality of education, and normally when we're talking about psychiatric or psychological statistics and quality of education, we're really not talking about quality of education. We're talking about numbers of years of education attained. Right? And that's where the dirty little secret is. The factors that we use don't fit. They don't really work. They don't help explain those cultural differences that may allow us to actually create normative samples. And yet the rationale, the reason of, as Professor Kaur said, one size fits one, is what's most important. Being able to look at that culture and look at that individual, and we still struggle with how to look at that individual from a research point of view so that we can gather the kind of data that we want. I don't know how we're going to do that, but that's the struggle that we have. And until we do that, what often occurs is we continue to create these research paradigms that are not successful. Let me go to the next two very quickly. On June 29th, the Berkeley conversation was on race and health. And Professor Bridges, Kiara Bridges, presented an amazing discussion on an issue that I know is very sensitive, and I apologize, I do not mean to step on anyone's feet, but that is the role of implicit bias, right? And we've been watching implicit bias for 20 years now or longer. Implicit bias really, as she described, and I would have to agree, moves us away from structure and an investigation of structural racism rather than toward an investigation of structural racism. Because implicit bias, to a great extent, is about the person. Is the person biased? Is the jury biased? And I certainly understand those instances, particularly around jury instructions, where implicit bias may be very, very useful in trying to gather some information about this jury, the unconscious biases that they have. I would suggest to you that the COVID has kind of blown the lid off of unconsciousness, right? And those things that we thought perhaps may have been unconscious, we know, well, maybe not. You know, maybe not. Maybe just there wasn't enough pressure to bring them to the fore. But certainly, as we look now, I have real concerns about this issue, the issue of implicit bias, and whether it is really a way that the law has used, and to some degree appropriately so, to gather more information about the jury, but in fact, in the long run, hurts us from a race point of view, really understanding the implications of race and really understanding the implications that in the long run, for me, are much greater and much more damaging, and those are of structural racism. The third one, and I'll do this quickly, has to do with Proposition 25. And for those of you that I'm sure have already voted or are close to it, I should have my sticker on because my wife and I actually took it over yesterday. So, Proposition 25 is a referendum on law that replaced money bail with system based on public safety and flight risk. Well, I love this. When I saw it, I'm giving you my bias. When I saw this, I thought, wow, this is really something that I'm interested in, something that I really want to be involved in. I started reading the background, and there was a paragraph, pre-trial risk assessment tools. Now, I don't know if anyone else, you know, were interested in that, but when I looked at pre-trial risk assessment tools, I dug in deeper, and it made me realize that Proposition 25 was about bail, not just about taking out bail, but about taking bail away for those that met the criteria of the pre-trial assessment tools. Now, Professor Jennifer Skeen at Berkeley has done significant work at these pre-trial assessment tools. Many of them are based on the Hare Psychopathy Index, which you can tell what it is just by its name. We know that many of these tools have what are called confirmatory bias. By the very questions that they ask, they have a significant confirmatory bias that is often racist at its base. The assumptions are racist at its base. And so consequently, we again are faced with this lack of intersectionality. The structure to how to make these pieces fit together in a way that we can actually talk about race and mental health and the law. It's difficult. Thank you.
All four of you were so terrific. Thank you. We've got a question on the Q&A, and I've been sent a couple of questions. Let's start with the one that came on the Q&A. Could the panelists speak to the impact on people of color when they experience racism and are not believed?
I'll start with that, Irwin. I wrote a piece, and I'm happy to share it, that was published in Ms. Magazine about my experience in Minneapolis with my daughter and the troubles that she experienced, so much so that she refused to come back home from China to finish out her senior year of high school because of the racism that she encountered. I think it's deeply troubling. I think it forms its own form of trauma itself. I think it's intergenerational. To some degree, it's been relieved slightly by police dash cams. For years, Black people had been talking about police abuse. And if we think about the history of policing in the United States, then we know that police patrols were originally slave patrols. And so it shouldn't come as a surprise, the concerns that Black people were raising in the wake of Michael Brown's death. But yet it's been very, very troubling to get a collective movement behind that. And really, if you think about it, not until we had to see a public lynching through the death of George Floyd have Americans taken a really deep breath and pause to think about exactly what this long legacy has meant in terms of Black people articulating this. And to be clear, this is not a trauma story of just Black people. It's Indigenous people in the United States, it's Latinx people in the United States, it's Asian people in the United States. And so I think the trauma is added to by the failure to be believed.
Do others want to speak to this question?
Well, just quickly, I think that there has been a transition, and Professor Haney Lopez spoke to this in that same presentation. If there's a difference, it's that we're seeing an expansion of people seeing it. And that's so important. People seeing it, not being able to run away from it, not being able to hide from it. You know, as we all know, this is really a white issue. This is not a Black issue, right? And as you see more people, white people, they're able to see it and not run away from it, I think it changes the quality of the conversation.
I'll say one thing about this. I would highly recommend an article by my colleague, Professor Russell Robinson, called Perceptual Segregation, on the very different realities that different groups are in terms of the way that they acknowledge and understand experiences of racism and the history of those. I'll also say that the Pew Center for Research has a lot of data on the very different places that racial groups, especially whites and Blacks, are at in terms of acknowledging racism. This can be very, as my colleagues have just talked about, this can be extremely alienating and potentially even traumatizing for folks who experience racism when they're basically when that reality is not being experienced by another group. Those numbers tend to shift. They shifted in 2014 to 2016, but then they went back down. So I agree with Professor Woods about changing the conversation has changed, but it takes a lot of work to maintain that change.
Right.
I could add just one thing to that. It would be that this kind of silencing that the person asking the question is talking about, of course, it directly impacts everything we've heard today and are talking about regarding belonging. And with mental health, this mantra that people have been told for the longest time, that unless you love yourself, no one else will love you, or all you need to do is believe in yourself. And I really like the way Dr. Bruce Perry talks about this when he says, the truth is you cannot love yourself unless you have been loved and are loved. The capacity to be loved cannot be built in isolation. So when we disbelieve, when we question people's truths, when they have the strength to tell us their truths and we question them and can't even listen, we don't even get anywhere close to that kind of loving that is required in order to break isolation and truly build community.
And Irwin, if I could just quickly
Please,
add
go
to
ahead,
that,
Michele.
is that there is an intersection of race and sex in that. So if you think about the Me Too movement, which largely kind of blew up with white women, but was actually started by a woman of color, is that not the history of the United States, right? Sort of Black women articulating sexual assault and rape violence. And the fact that that's been papered over. And we could see a direct example of it in Thomas Jefferson and Sally Hemings. The very bedroom that Sally Hemings had at Monticello was papered over and made into a men's bathroom so as to erase her entirely. And the fact that she was a person who bore 6 of his children, starting when she was 13 and taken to France with him. And so I think that there's an intersection in what we've all been saying there of both race and also sex when we think about the narrative of being disbelieved.
We have just a couple of minutes, and this is a question that was sent to me. Law school is very stressful, especially for students of color, students from marginalized groups, and those who are first generation to go to college. Do you have specific suggestions on what law school should do to decrease this stress?
Hi. As someone that's watched, and we all that have watched this over time, I do think that the law schools have a specific responsibility to reach out, as Professor Kaur said, to reach out around certain issues. This may be my clinical background, and it may be completely wrong, but I assume that students have been traumatized. That's just an assumption. That's my first assumption, and they have to walk me back from that. And I assume, and I'm really moving away from the issue of resiliency, which was for the last 20 years is where I've been, to resistance, right? I think that resiliency served a certain purpose, but now I'm really looking at resistance. And so if I'm in a position to talk to students about their academic experiences, if they're in my class or what have you, I mean, I don't say, have you been traumatized, but I certainly assume that this is someone that has been traumatized in their experience, and that there are ways in which we can ameliorate that trauma by counseling, by mentorship, automatic, rather than waiting until they express some sign, which in my opinion, by the time a law student expresses some symptom of being undermined, they're way, way down the line.
Does anyone else want to speak to that?
I'd say that I think it helps to share stories, both of our own vulnerabilities and privileges, so students and other attorneys and indeed fellow colleagues stop thinking how someone does it all and instead realizes a lot of unearned, perhaps access to resources or other good fortunes that the person has had, as well as the vulnerabilities they've overcome. I know a lot of students have commented, and I personally have found in the recent tributes to RBG, for example, we know that it was, blatant gender discrimination that came in the way of employment, even with the brilliance and all the academic success she displayed. But it was also very helpful to recognize for a lot of people the inherited education funds, as well as her Marty Ginsburg, and to recognize that she then employed some of the benefits she enjoyed, of course, employed them tirelessly for the benefits of other generations. But that kind of human story and what we bring and how we are, where we are, I think helps to begin alleviating this idea that anyone completely does it all or does it in isolation, and that it's all based on sheerly their hard work and their smarts. So that's one thing I would suggest.
And I would just add to that I think that there are ways in which professors have a role here in recognizing the myriad forms of excellence in the classroom. We know the stories of women and people of color feeling shut out of the law school classroom, that what they have to offer is not valued. And I think a lot of that has to deal with what we see as valued in terms of what we teach and how we teach in the law school classroom. There are many stories that just simply aren't told, and that if there were certain cases told in a different kind of way, we'd hear a different kind of vocalizing coming from women and coming from various communities of color in the classroom. And so I think that professors have a role of mindfulness, and that mindfulness is connected with excellence. I think one big problem is thinking that as we elevate the stories of women or people of color, that we're not being excellent in that way, and being excellent is only one way. And that is so not true at all. And so I think that we can do a better job as classroom professors to help to alleviate some of the stereotypes and stigmas that come about through how we teach.
I would agree with all three of the speakers on everything they said, and I'm happy to speak after the panel if someone wants to talk about legal education settings and belonging. One thing that I'll add is just at the base of this is the fact there are so many things that are taboo or that we just don't talk about, whether they're taboo or not. So we don't talk about socioeconomic status in education, or we don't do it enough, for example. And just by raising these issues, we learn, as Professor Kaur has just described, we learn that other people have had these experiences. We learn about what type of support to access. We learn about resources that might be available. Otherwise, all of these things either remain hidden or we think that maybe it's stigmatized, right, to have these concerns.
Last, we're out of time. Again, my thanks to each of the speakers for their wonderful presentations. Thanks to everyone who tuned in. And next week at this time, we'll have a panel put on by our Coalition of Diversity as well as the Dean's Office, focusing on Prop 16, which seeks to repeal Prop 209. And we'll discuss that in the context of race and the law. Thank you all. Take care and be safe.
Thank you all. Thank you, Irwin.
Thank you.